Hello everyone, I hope you all are doing well. So today I will continue the next lecture of polity, and before it I would like to say something regarding polity. So if you do you think polity is boring subject? No, it's totally wrong. Every right you enjoy today, a speech, vote, protest, whatever, exists because of polity. If you want power and understand how it is built, let's decode the system that control everything around you. So polity is not just a theory, it's your life in action. Okay, so just unlock your polity knowledge or whatever in polity I will unlock totally. So let's begin it. So firstly I would like to cover the preamble. you know uh, the idea embodied in the objective resolutions are faithfully reflected in the preamble to the Constitution, right? Which, as amended in 1976, summarizes the aims to and objective of the Constitution. So, text of the preambles we know, we the people of India, having solemnly resolved to the constitute India into a sovereign, socialist, secular, democratic republic, and secure to all citizens, right, justice, social, economic, and political liberty of the expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individuals and the unity and the integrity of the nation in our Constituent Assembly on this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. So, uh, N.A. N.A. Palkiwala, an eminent jurist and constitutional expert, called the preamble either identity. Okay, now preamble to the Indian Constitution is based on the objective resolution drafted and moved by Pandit Nehru and adopted the Constituent Assembly. Now, preamble is not enforceable in a court of law. The preamble has been amended only once so far, in 1976, by 42nd Constitutional Amendment Act, which added three new words: socialist, secular, and integrity. SSI, right? Socialist, secular, and integrity, 1976. So this amendment was held to be valid in case of double, or you can say the Supreme Court has referred to the preamble to elucidate vague aspects of the Constitution. Now, in the Berubari case, the Supreme Court held that the preamble was not part of the Constitution, but later in the Keshwananda Bharat case, it declared that it was the part of the Constitution, right? So, let's move uh, reorganization of a state. So, this is also important. A bill seeking to create new state or alter boundary of existence, existing states can be introduced in either house of the parliament only on the recommendation of the president. President refers the state reorganization bill to the state legislature concerned for its opinion, fixing a time limit, right? So parliament is not bound to accept or act upon the views of the state legislature on a state reorganization bill. Now the state reorganization bill requires simple majority in both houses of the parliament. It is not necessary to obtain the views of legislature of union territory before a bill affecting their boundary or names is introduced, right? Now I would like to discuss some timelines of a state and union territory. So in 1956 there were 14 states and 6 union territory, and Andhra Pradesh was created in 1953 and Kerala in 1956, and In 1956, Karnataka was created. In 1960, Bombay state has bifurcated into Gujarat and Maharashtra states, right? So in 1962, Nagaland was created as separate state, and in 1966, Haryana was carved out of Punjab, and Chandigarh became a union territory. In 1970, the Union Territory of Himachal Pradesh was elevated to the status of a state. Right now, in 1971, Manipur, Tripura, and Meghalaya were granted statehood. In 1974, Sikkim became an associate state of the Indian state by the 36th Constitutional Amendment Act 1975. Sikkim became a full-fledged state of the Union of the India Union, right? In 1986, Mizoram and Arunachal Pradesh came into being, right? And in 1987, Goa came into existence, and 2003 more new states, Chandigarh, Chhattisgarh, Uttarakhand, and Jharkhand were created, right? On 2nd June 2014, Telangana was made a new 29th state after separating from Andhra Pradesh, with the city of Hyderabad as its capital, right? So the state of Jammu and Kashmir is fabricated, and two new union territory are formed out of it. So Jammu and Kashmir Union Territory and Ladakh Union Territory on 5th August 2019. Now the union and its territories. Article 1 describe India, that is Bharat, as a union of states. Now according to Article 1, the territory of India can be classified into three categories: territory of a state, union territory, and territory that may be acquired by the government of India at any time. So at present, there are 28 states and 9 union territory, and Article 2 empowers the Parliament to admit into the unions of India, or you can say establish new states on such terms and conditions as it thinks fit, right? So Article 3 authorize the Parliament to form a new states by separation from new any states, or by uniting two or more states or parts of states, right? Or by uniting any territory to a part of any states, and then increase the area, right? Increase the area any states, diminish the area of any states, alter the boundary of any states, alter the name of any states. So all these come under the union and its territory, right? So the Citizens Act 1955 provides for the acquisition of Indian citizens in the following ways. Generally, every person born in India on or after January 1950 shall be a citizen of India, or either of his parent was a citizen of India at the time of his birth, right? A person who was outside India on or after 26th January 1950 shall be citizens of India by descent if his father was a citizen of India at the time of that person's birth. So a person residing in India for more than 7 years can seek citizenship by naturalization. If any new territory become a part of the India, the persons of the territory become citizens of India, right? So citizenship of India may be lost by renunciation of citizenship, termination of citizenship, if citizens of India voluntarily acquires the citizens of another country, and deprivation of citizenship by the government of India. Now overseas citizens of India, OCI, that is Citizenship Act, has been amended in 2003, by which people of India origin except in Pakistan and Bangladesh will become eligible to be registered as the overseas citizens of India, OCI, right? Now fundamental rights. So the fundamental rights have been described in Article 12 to 35 Part 3 of the Indian Constitution. Now the right to property, Article 31, was deleted, right, deleted from the list of fundamental rights in 1978 by the 44th Amendment Act 1978. It is made a normal constitutional right under Article 300A in Part 12 of the Constitution. So, Article 14 of the Constitution states that the state shall not discriminate against any citizens on grounds only of religion, race, caste, sex, place of birth, or any of them. No citizen shall, on grounds only of religion, race, caste, sex, place of birth, or any of them be subjected to any disability, liability, restrictions, or conditions with regard to access to shop, public restaurant, hotels, and place of public entertainment, or the use of wells, tanks, bathing, ghats, roads, and places of public resort maintained wholly or partly out of state funds or dedicated to the use of general public, right? So nothing in the article shall be prevent the state from making any special provisions for women, children, or any socially and educationally backward classes, right? So Article 15 prohibits of discrimination on certain grounds. It says that the state shall not discriminate against any citizens on grounds of religion, race, caste, sex, or place of birth, right? So uh, Article 16 guarantee equality of opportunity in matters of public employment. It says that there shall be equality of opportunity for all citizens in matters relating to the employment or appointment to any office under the state, right? So no citizen shall, on grounds only of religion, race, caste, sex, descent, place of birth, or any of them be ineligible for any employment under the state, right? Now reservation to in economically weaker sections. So constitutional one third constitutional amendment act, okay. So uh, 2019 so under this it is provided a 10% reservation in general government jobs and educational institutions to the economically weaker sections of society, that is EWS, among those who are not covered under any reservation plan. So the Mandal Commission case, a 9-judge bench of the Supreme Court has laid down in Indra Sahni case, popularly known as the Mandal Commission case, regarding reservation in government employment. So, and under Article 16 Clause 4, provisions can be made in favor of the backward classes in the matter of employment by executive order also. So the backwardness contemplated by Article 16 Clause 4 is mainly social. It needs not be both social and educational. So the reservation contemplated in Article 16 Clause 4 should not exceed 50% reservation. So reservation of post under Article 16 Clause 4 is confined to initial appointment only and cannot extend providing reservation in promotion. So Mandal Commission was set up in 1979 under the chairmanship of B.N. Mandal, MP, that is former Chief Minister of Bihar. Okay, so the 77th Amendment has provided to continue reservation in promotions for SC and ST, and Article 17 ensure abolition of untouchability. Article 18 ensure abolition of title. It prevents the states from conferring any title, right? So this ban is only against the state and not against the other public institutions such as university. The state is not debarred from awarding military or academic distinctions even though they may be used as a title. So Bharat Ratna or Padma Vibhushan cannot be used by the recipient as the title and therefore does not come within the constitutional provisions, right? So right to freedom. So Article 19 to 22 19 to 22 right to freedom of speech and expression and right to assemble peacefully and without arms, right to form association or unions or cooperatives, right to move freely throughout the territory of India, right to reside and settle in any part of the territory of India, right, and right to practice any professions or any carry on the any occupation, trade or business. A state can impose restrictions on the freedom of speech in interest of the sovereignty and integrity of India, the security of the state, friendly relations with foreign state, public order, dissent or morality, or in relations to contempt of court, defamation or incitement to an offense, right? So restrictions can be imposed on right to form association in the interest of the sovereignty and integrity of India or public order of morality. Restrictions can also be imposed on freedom of movement, right? And you can say reside and settle in the interest of the general public order or morality. Restrictions can also be imposed of movement and reside and settle in the interest of the general public or for the protection of interest of any scheduled tribes. Freedom of press is included in the wider freedom of expression, which is guaranteed by freedom of expression under Article 19. So Article 20 protection in respect of convictions for offense. It grants protection against arbitrary and the excessive punishment to an accused persons, whether citizens or foreign or legal persons like a company or a corporation. So Article 21A makes the right of education for children of the age 6 to 14 years of fundamental right. 86th Amendment Act 2002. Now Article 21 of the Constitution provided that no person shall be deprived of his life or personal liberty except according to the procedure established by law. So in England, courts have no power to individuals a law made by Parliament. In Meneka's case, the Supreme Court held that a law made by the state which seeks to deprive a person of his personal liberty must prescribe a procedure for such deprivations as must not be arbitrary, unfair, or unreasonable. It follows that such a law shall be invalid if it violates the principle of natural justice. Article 22 provides that no person who is arrested shall be detained in custody without being informed of the ground for such arrest. So every person who is arrested and detained in custody is to be produced before the nearest magistrate within a period of 24 hours of arrest, excluding the time necessary for the journey from the place of arrest to the court of the magistrate, and no such persons can be detained in custody beyond that period, right? So without the authority of a magistrate, the constitution authority the legislature to make laws for preventive detention, right? So this is important. Now move to right against exploitation, Article 23 and 24, right? Article 23 provides right against exploitation in following respective, like traffic in human being and beggars and other similar forms of forced labors are prohibited. Now special provisions for the protection of children is Article is made in Article 24, which provides that no child below the age of 14 years can be employed to work in any factory or mine or engaged in any other hazardous employment, right? So right to freedom of religion, Article 25 to 28, right? So Article 25 provides freedom of conscience and free profession practice, right? And propagation of religion subjects to public order, morality, and health, right? Article 26 guarantee following rights to all religion ground subjects to public order, morality, and health. That is, establish and maintain institutions for religious and charitable purpose, manage its own affairs in matters of religion, okay, and own acquire movable and immovable property. Now administer such property in accordance with the law, and the state cannot compel any citizens to pay any taxes for the promotions or maintenance of any particular religion or religious institutions. Article 27. Now, no religious instructions can be provided in any education institution wholly maintained out of a state fund. Article 28, right? So cultural and educational rights, Article 29 to 30, where religion community is in the minority, the constitution enables it to preserve its culture and religious interest by providing that the state shall not impose upon it any cultures other than the community's own culture. So, such a community shall have the right to establish and administer educational institution of its choice, and the state shall not, in granting aid to educational institution, discriminate against such an educational institution maintained by minority community on the ground that it is under the management of a religious community. Okay, Article 30. So full compensations has to be paid if the state seeks to acquire the property of a minority educational institution. Article 30, Clause 1A. Right to constitutional remedy. Article 32. Right to constitutional remedy, which was termed soul of the Constitution by Dr. B.R. Ambedkar, has been guaranteed by Article 32 of the Constitution. Now, writs. So, the power to issue these writs for the enforcement of the fundamental rights is given by the Constitution to the Supreme Court, Article 32, and High Court, Article 226, right? And Supreme Court has the power to issue writs only for the purpose of enforcement of the fundamental rights, right? Now, uh, under Article 226, High Court can issue writs for the purpose of enforcement of fundamental rights and or for the redress of any other country of illegality. A writ of habeas corpus calls upon the persons who has detained another to produce the letter before the courts. Okay. Now the words habeas corpus literally mean to have a body, right? So mandamus literally means command. It uh, it commands the persons to whom it is addressed to perform some public or quasi public legal duty which he has